Hello and welcome back to another episode of Sidebar Social. I am Dana Stewart.
And I'm Jennifer Grinke.
Okay, so how's everything going at home with the dog?
So my dog's been gone 3 months at training.
Yeah.
I have a mini golden doodle.
Named London.
Named London, and she's wild. And so she came back, and she is still wild.
Okay, so what happened with the cake or whatever you had? You were telling me that you and Ashlyn had cake or something?
Yeah, so apparently I didn't know this, but my 9-year-old made basically a step stool situation so that the dog could get up to the bar stools.
Yeah, because your dog's little.
Yeah, it's like 7 pounds. Then she left an entire piece of cake. So I'm like, hey, I'm going to go in the room. I'll be right back. I come back. The dog is on the counter and has eaten the entire cake. So that's how my week's going.
That training was money well spent.
Yeah. No, I will say she's a lot better. So that's good, but she's still always going to be wild at heart.
How does it work, though? Do you have the training that you still have to do with her? Like, you know, now that she's back from the actual trainer?
Yeah, I'm supposed to like let her know that I'm the boss.
Okay.
So can you imagine how that's going?
Yeah, I'm sure it's great.
Yeah, it's going well.
So trying to corral your dog, I feel like it's kind of like sometimes with clients that we have to deal with, right? We're trying to teach them what to do and what not to do. You ever feel that way?
Yeah, I definitely feel like that happens a lot in our cases. And then there's a lot of stuff that's just, outside of our control.
Yeah, things that we didn't see coming.
For sure.
Yeah, and that's kind of gets us into the topic of today's show, right? So we have a friend here. And
yes.
Yeah, and do you want to do the introduction?
Yes, we are so lucky today. We have Andrew Jee here. He's a criminal attorney that we work with often on our cases. Hey, Andrew, how are you?
Hey, guys. Doing great.
Hello.
Thanks for having me.
Andrew, you understood the assignment. You have your pink tie on.
I went and picked out something out of my large collection of pink ties.
Well, you've just checked all the boxes in Jen's book, so job well done.
Well,
you're hired.
Well, thank you.
So how are you doing today?
So far, so good. It's still early. There's plenty of time for people to get arrested later this afternoon and call me Saturday morning.
Well, so I feel like we should probably give people some context as far as your background. Can you speak a little bit about your practice and what you do?
Certainly. So I'm primarily a defense lawyer here in Dallas. So I represent people, good people that are having problems with either civil or criminal cases. And I try to help people get out of tight spots.
And how long have you been doing that?
So, gosh, it's been almost 20 years.
Wow.
Wow.
And I know that our firm has worked with you quite a bit with cases, and you've been a big help to many of our clients.
Yeah. And what I love about you is you're just so easygoing. And somehow when I call you, you always answer the phone.
I do my best.
It's a good characteristic.
You're smart. You don't always call first thing in the morning when I'm in court. So I try to keep the line open for the afternoon.
Does Jen have like the red president's phone, that direct line right to you?
Yeah.
Well, it does show her name, so I do know that.
Okay. Got caller ID.
People who are watching might not realize that oftentimes in family law cases, we intersect with criminal, whether it's a past crime we're dealing with, a current crime, or maybe they want to commit a crime.
Well, we try to not commit future crimes, but certainly many people have had criminal issues pop up in their past, and that's something that often, if there's a custody issue, that we have to deal with. And unfortunately, sometimes people are arrested either just before or during their divorce, if it's family violence or child abuse, something of that sort, and the other side is actively trying to use that as leverage to get a better deal in the divorce. So that's something we normally need to address and work with them to make sure that they get a good and fair outcome for them.
And a conversation that we've had kind of behind the scenes, I think it'd be helpful for the viewers to know about, is the strategy when we're dealing with that, right? So yeah. Jen and I are representing somebody going through a custody battle, divorce, whatever it might be. They're facing a DWI, right? So the client's working with both of us. And we have to figure out the strategy if we have a hearing coming up on how are we going to navigate getting into the alleged crime that this client has committed. So I'm just curious if you could speak a little bit about that as far as from your perspective, kind of pitfalls or things we've got to be aware of to try to help you be able to protect them from a criminal side.
Yeah, so obviously it really depends on the facts, right? And what the allegations are. It also depends in many circumstances if there are children involved. So if you're 70, you're getting a divorce and you have a DWI, all your children are 40, probably not really going to be that big of an issue.
Right.
But if you're a young father or young mother and there's a DWI child passenger, you can bet that's going to come up. You're going to get CPS involved in your case. Your spouse's lawyer is going to bring it up, and you can expect the judge to be very interested in that. So you really need to determine how you're going to handle that. And so we typically want to look at the actual case and see, is this a defensible case? Is this something that we need to have a strategy to mitigate the damages? Or do we really just kind of want to sidestep and not really do anything at all and take the position that you're presumed innocent, and until the case goes to trial, you're not really going to say anything?
In your opinion, is it important for somebody who has a DUI and they're going through a family law, let's say a divorce, to also have a criminal attorney involved, not only on the side of the criminal case, but as well in the family law case?
So yes, and I think typically that's where we do a good job working together. So if I'm representing somebody in a criminal case, as we've done before, I can usually interact with you on a limited basis to give you input on the criminal case, give you information, give you a little bit of guidance. And that's really something that can be done very effectively and on a very good value basis for the client. Typically, it doesn't make a lot of sense to go out and have your own criminal defense lawyer and then someone that's just a liaison between that lawyer and your family lawyer. And that's usually a little overkill, I think.
And you mentioned whether kind of analyzing if there is a defensible case. I realize it's probably very fact specific, but what things are you looking for when you're making that determination if it's a defensible case?
So, well, here's a case that we worked on together several years ago. Our client was a young lady. He was accused of assaulting her husband. She was a very small person. He was a very large person. Allegedly, there was some video that was destroyed. And
allegedly.
And when we got the witness statements about 6 months into the case, the only statement from an independent third party said, nobody touched anybody. I mean, that was a case that ended up getting dismissed by the district attorney's office. But unfortunately, that's a case that the fairly aggressive lawyer for the husband used it for months in the divorce case to say how the husband was an abused person and needed extra financial support. And he really caused a lot of chaos until we got that case tossed out. But that's not always something you know until you get the evidence in the criminal case.
Yeah, and do you have a kind of a blanket rule of if a client is going through a family law matter and they're also facing a pending criminal matter, that they don't get into any discussion about the allegations on the criminal case?
As a jumping off point, yes, right? Because until you really know what you're dealing with, you don't want to make a bunch of statements that you can't later retract. And I don't say that because clients are dishonest, but they don't always know what somebody else is alleging against them. They also don't know what's in the police file. They only understand the case from their perspective, and there's usually a lot else out there. And so they don't want to really speak until they really fully understand all the facts and circumstances surrounding their case.
So can anything they say in their family law case then be used against them in the criminal case?
Potentially, yes. And in Dallas, for example, we have some courts that the family law courts go to, the associate judges, that don't have a record. So there's not a court reporter. That's a little harder. But in Collin County and other counties, most all hearings are on the record and there's a court reporter. And if someone was very enterprising, say an ex-spouse, they'd go down and order that transcript and hand it over to the district attorney's office. So yeah, what you say can and often will be used against you.
And so potentially early on, you may advise us as the family law attorney for a mutual client to instruct them to take the Fifth Amendment, assert their Fifth Amendment right if they're being questioned in a family law hearing about an alleged DWI or whatever it might be?
Yes, and typically where it comes up is family violence assaults. And if you have a person that's arrested and then there's a divorce filed almost contemporaneously with that, and then there's a very quick hearing on temporary orders, often you won't know anything about the criminal case yet. And if you have the other side gets up there and makes a convincing statement, the judge is pretty much going to go with that person whether or not it's true, and unless there really are some very strong facts to the contrary. So by talking, you often just dig yourself a deeper hole. You don't really get yourself out of it. And that's an unfortunate reality. So sometimes it's better just to take a moment, see what's happening, and then once you have the evidence, come back and put your defense on at that time.
Yeah, and kind of what I see sometimes in those domestic violence situations, especially at the onset of the divorce, is a lot of times like the person in your seat, the criminal attorney, saying, don't say anything because we don't know what is going to really hurt you in the criminal case yet. Is that kind of what you see?
Yeah, a lot of times, right? And think about the case we just talked about. You've got a situation where someone alleges, family violence against them, but they're lying, right? And, the evidence they have has actually been destroyed or lost, and it really turns out that there's nothing there. But you don't know that at the beginning. So sometimes it's best just to say nothing, but the lawyer can always put on a cross-examination of the supposed victim, right? Did the person go to the doctor? Are there medical bills? Are there pictures? Are there a history of abuse? Were the police called? Were there third-party witnesses? And often that can be used to discredit the person.
And are those things in your practice where if a family law attorney wanted to hire you, that you would work with that attorney to help them understand, hey, these are areas of attack for the opposing side?
Absolutely, yeah. I mean, in fact, I did that recently, a couple of weeks ago, family violence protective order up in Collin County, where we had 2 women that shared a husband at different times. And, of course, there was some conflict there. And number 2 had gone against number 1, claiming that she had attacked her, and including an allegation she tried to run her over with a car. Once we went through the case and we realized that allegation was raised about 8 years ago in a trial, we're able to get that excluded under some legal theories that you can only try your case once.
Yeah.
And then the newer allegations really were not actually family violence. I mean, there were some fairly negative comments, but just being mean and nasty isn't family violence. And so we're able to get that case dismissed.
Follow us and join the conversation on Instagram and YouTube at Sidebar Social.
To learn more about Greinke Stewart Family Law, visit GreinkeStewartLaw.com.
Okay, Andrew, let's go through some hypotheticals.
Fun.
I'll start the meter.
There's a client comes in and they are in their family law case and they provide us with a bunch of videos, texts, emails that they got off their spouse's phone. What are some criminal implications of that behavior?
So it depends.
Love that answer.
Always depends.
And it's very difficult, right? Because on the one hand, there are some very onerous criminal statutes regarding accessing stored electronic information. That's a violation of both federal and state law. There are also some wiretapping acts. There's also a practical challenge, and that is that a lot of people, like if you don't have a password on your phone, or you tell your spouse your password, then there's an issue about, did you allow the person to access your phone? And that's often disputed, okay? So you have a full range of outcomes from something very serious to almost nothing. The problem with these self-help remedies is anything that's obtained illegally is not admissible in court. And if the judge thinks you're the person that's like lying and cheating, trying to hack into your spouse's email or telephone, any kinds of communications, that can really poison the well against you for all the decisions in your case. So you've got to be very careful about it. And it's best not to do, because lawyers like you know how to get that same information through the discovery process.
Yeah.
So it's usually not a good thing to do these self-help remedies, right? And you kind of know if it's wrong. If you're putting a tracker on someone, you're accessing their phone without their consent, you're looking at their text messages. If you take a parenting app and you install it on your husband or wife's phone,
good idea.
You know you're not supposed
Write that down, Jen.
You know you're not supposed to do that. And if you make those decisions, you're likely to suffer the consequences.
So, Andrew, you mentioned to us, we know how to get information through the discovery process. What about forensics? Seizing a device, computer, cell phone, whatever it might be, have you worked with companies who do forensic imaging, and do you think that is something that can be viable to help turn up evidence?
Absolutely. I've got a guy, right? And typically there's a variety of things you can do, whether it's getting direct access to the device and making a copy and doing searches. That's actually pretty difficult to do. It's also expensive. But there are also some things you can do in terms of sending a discovery request. So you contact their lawyer and you'd ask them to produce all of their messages. Typically what will happen is someone will say, oh, I lost my phone. I dropped it in the pool the week prior to filing divorce.
Right? Oh, how convenient.
And typically when you see those things happen, then I think people become very skeptical. And then the other side often doesn't have the evidence that might be really hurtful to our client. So sometimes that's actually a little bit of a benefit. Another thing you can do if you get into things early enough is you can issue subpoenas to the telecom people, right? And you can get call logs. It's often difficult from practical stint to get the text messages. But if you see that somebody has called the same person 10 times a day for a year, you can kind of know that's someone you need to.
It's just my friend.
And it very well could be, right? But you know that's someone you need to dig into further.
Yeah.
And once you have that other person, you can then get some discovery from that person directly. So you might be able to get the other half of those messages from the phone that was destroyed.
I see.
I think a lot of times there's this misconception that, hey, I'm the one on the phone bill. Like it's my phone bill that I control for my husband. I can look at his phone. Is that legally correct?
And I think Mrs. G would probably share your view on that. And people really do feel entitled to look at their spouses or boyfriend or girlfriend's phones. I mean, people really think they have the right to do that. And the Texas legislature has passed some new laws in the most recent session that really cuts back on that. I mean, you have to have what they call meaningful informed consent now. So if you're on the bill, you can probably call and get a copy of the bill. But that doesn't give you the right to go and access the physical device and hack into it, right? And again, that's going to trigger a lot of negative consequences for your case, right? Including the exclusion of potentially good evidence for you and poisoning the well against you on other topics.
And what about tracking devices on a vehicle? I mean, we've seen that, right?
Mm-hmm.
Yep.
So is that legal? Is it illegal? Does it depend?
So two things, right? First the problem, then the solution. So generally, if it's your vehicle and it's you own a fleet of trucks and you put a GPS device on there and your workers are driving around, 100% okay, right? If it's your car and you have it on there, probably not going to be an issue if your spouse borrows your car. But if you take a tracking device and put it on the car that your spouse drives, 99% of the time, and you don't disclose that, you're going to have a problem, right? Because that's not going to be informed consent.
So basically you're a stalker at that point.
You are. And are you really going to go to jail for that? Probably not, right? But what it does is it exposes risk. There's a risk issue for you in the criminal case. You may have to get a lawyer, spend more money. Any evidence you get can be excluded. And again, the judge is going to hate you. But here's the solution. You can issue a subpoena to, say, the tollway and find out if they've been driving up and down the tollway, find out where they are. And there are other tools that you can get through either your law firm or a private investigator. That there's an enormous database of license plate scans, and you can, through the right process, you can access that and see where cars are going. Not in real time, but you can get a lot of information about that.
And what about the hidden tracker I have in my daughter's car? Is that legal or illegal?
So
she's an adult, by the way.
So if she's 16 and it's your car, you're probably not going to have a problem, especially if you say, as a condition to driving this car, you're going to need to have a tracker on it.
Oh, she doesn't know about it.
Well, call me off air.
She knows that.
She's not going to watch.
But
Okay.
But often if you have bad credit and you finance a car, right, they'll have a GPS on there. So when you don't make the payment, they know where to come get you. You agree to that. There is a way to do that legally. It's just the hidden and deceptive access that causes the problem.
So, Andrew, earlier you mentioned sometimes the client has to plead the Fifth Amendment in either the criminal case or in the family law case. What impact does that have on the family law case?
So maybe we should just back up and let people know what that is. So if you can't be compelled to testify against yourself in a criminal case. Mm-hmm. Prosecutor can't call you as the defendant to the witness stand. That's never going to happen. But in a civil case, you can be called to the witness stand, and the lawyer for the other side can start asking you questions about the underlying facts of your criminal case. And you can either answer those, which waives your Fifth Amendment in your criminal case potentially, or you can say, I'm not going to answer, okay? Normally, it's best to follow the general rule, and that is, if you're in a pickle, drop a nickel, right? Keep your mouth shut and take the
writing
fifth,
this down.
right? And the reason for that is in a family law case, most of the time, the burden of proof is going to be very low. It's going to be preponderance of the evidence, so a little more likely than not, versus a criminal case where it's beyond a reasonable doubt. So you're probably going to have a very hard time defending those allegations in the family law case, even if you testify, because typically your testimony is going to look self-serving because you're just going to deny it. So that doesn't really add a lot to it.
Yeah.
And you create a lot of risk for yourself. You really don't do yourself any favors. And sometimes you take the zing out of it by just saying, hey, we're not responding. Okay.
But then, where we sometimes get into an issue, because I hear you, right? You want to not respond, protect the client on the criminal side. But then what people may not know is in the family courts, then a judge can take that lack of a response as a negative inference against the client, basically meaning that the judge can assume that whatever is being alleged is true.
If there's any other evidence, yes. And just the other party's testimony will do that. The practical reality is if the other party's convincing and you get up there and deny it, that usually isn't going to tip the scales in your favor. So it's really hard to defend these allegations just with your own testimony. So often you want to be very creative and look out to see what other sources of information can you bring in. So say, for example, it's a family violence case. Look around and see, are there any cameras in the home? Were there any guests present? Were there any neighbors? Does anybody know the past history of the clients? Were there text messages between the parties, right? If somebody, savagely beat up another person, would you expect a text message to say, oh, got home safe, see you later, right?
Yeah.
I mean, and so you've got to look for those other sources to make your case. And, it's very frustrating, very difficult for clients to realize that often they're not their best advocate and that they need to kind of trust their lawyers and figure out a way to present their case other than them just getting up there and saying, it's not so, it's not so. That, unfortunately, that just really doesn't work very well.
Okay, Andrew, it's time for closing arguments. So how this works, are you ready?
I'm ready.
How this works is Dana and I share a client, and we're each going to argue a different perspective on how we're going to present the case to the court.
Okay.
So for this situation, our client has a DUI, and it's whether or not we're going to allow him to talk in the family law.
Hold on. Allegedly
has a DUI.
There we go.
And it's whether or not we're going to allow him to talk in his family law trial. Go ahead, counselor.
So I feel like in this scenario, Andrew, we should let our client testify. I heard you earlier about your advice, and especially I know we're early on in the case. You don't have all the discovery, but he presents well. He's not a stumbling, mumbling client. I think he's going to come across well to the court. We have a lot of witnesses from church and the youth group that he runs that are going to come in and testify to his character and that they've known him for more than a decade. I think this was just a scenario where he going through a rough divorce, had a bad night, ended up making some poor decisions. But I think he can tiptoe around that through your guidance, our guidance, and show the judge who his real character is.
I disagree. So I don't think he should testify. This isn't his first DUI. It's his third.
Allegedly.
And anything he says in our case could be used against him in his criminal case. And if he's in jail, he's no use to his kids.
Well, I would go with Jennifer on this one. If it's a
Win again.
You always win.
if it's a felony, that you got to take that very seriously. If it's a first, I'd go with Dana, right? Almost anyone can have a bad situation, and you don't want to necessarily allow one poor decision to define your entire life. And if there's some good mitigation evidence that, it's a good guy, he's learned his lesson, it's not likely to happen again, that's probably not somebody that needs to, be punished by the family law court. And that criminal court can do that if necessary. That's what they do. Family law courts really don't punish people for crimes, and they shouldn't. But again, if it's a third time offense, there may be some issues there. Sometimes somebody like that may or may not want to admit that they have a problem, and so you can end up making your situation worse.
I must have missed a call with a client that said it was the third DWI. Okay, I didn't know this. I feel like Jen's changing facts to win the closing arguments.
Sometimes if you have a few drinks, you can't really count that well.
Yeah, that's true. Very true.
Exactly.
All right, Andrew. Well, hey, look, we want to thank you for coming on Sidebar Social today. Your information, I think, is extremely helpful and informative. I know our viewers are going to find it very helpful as well. And thank you for all the work you do for us and for our clients. We really do appreciate you.
Well, I appreciate you and your clients, and I'll see you down in the courthouse.
All right.
See you in jail.
See you in jail. All right, guys. We'll catch you next time on Sidebar Social. Bye.
Bye. To connect with today's guest, attorney Andrew Jee, you can follow him on Instagram at thebestdefense_TX. And to learn more about Andrew's law practice, check out his website, andrewjee.com. That's andrewjee.com.
So why did the police officer arrest the duck?
Why did the police officer arrest the duck?
For selling quack.
Okay, I didn't see that coming.
Do you have a t-shirt for that, too?
Oh, yeah. I love it.
The kind of jokes that are popular at my house.
Yes, yeah. I love it.